marijuana, but we are seeing it in all facets of our government, including our budget process.
Were you able to get a solid Democratic block of votes in order to try to counteract those things? Is there
26% that exist in your party that would vote against these?
You know, we have, over time, we have been attempting to, you know, coalesce and prevent the majority from at least getting immediate effect on a number of the bills. We actually had to file a lawsuit recently, we, you know, I don't know how successful that's going to be, mainly because, at least on, I don't know if you all have been following the immediate effect issue.
Yes.
Tell us about that, because that's been a big, we were concerned
for very good reasons.
Yes, because I'm sure if it goes down the way, in a bad way on these bills, there'll be an immediate effect, right? That's how they'll do it.
Well, I mean, you know, basically, the whole idea of immediate effect, you know, language was put into the 1963 Constitution during the Constitutional Convention for the specific purpose of basically protecting the minority, and so it basically said that all votes will you know, in other words, would not go into effect unless they're given immediate effect. And immediate effect would be given if two-thirds majority, upon a request of 1/5 of the members elected and serving, and immediate effect would only be given if 2/3 of the members elected and serving vote for immediate effect. That's sort of the general gist of it. And over time, and basically, under the House rules, immediate effect is routinely given on a voice vote. So literally, we will ask for a record roll call on immediate effect. They will not recognize us. They will basically put immediate effect on by voice vote, and that's how the record will reflect it. If you look to the record, it will say immediate effect was granted by a majority of members. But that wasn't the case because they didn't recognize our motion. So what we started doing a few months ago when we went to their leadership and said, you know, particularly on really damaging legislation, the emergency financial manager, basically the teacher tenure bills. I mean, just, you know, bill after bill, really, really very troubling bills, and said, you know, if you don't recognize us on immediate effect, we'll file a lawsuit. And so what we started doing is we started entering into the journal our no vote explanation, so that the journal would reflect that 47 of us would not have given immediate effect, even though the journal was saying that immediate effect was granted. We were entering no vote explanations. Finally, last week, or 2 weeks ago, we chose 3 of the bills, one involving U of M collective bargaining rights, and one involving the emergency financial manager bill, and then the third one I forget. But we asked for an injunction, and we got it. And then the Republican caucus turned around and asked the Attorney General to file an interlocutory appeal, which he did. And mind you, our lawsuit was entirely funded by private donations. So they used taxpayer dollars. The Attorney General then filed an appeal. The Court of Appeals reversed the lower court decision, and and I suspect that if we were to appeal that to the Supreme Court, well, we all know what the outcome of that would be at the Supreme Court. So, so in a sense, the question, I had coffee hours today, and the question was, well, why did you do it? Well, the reason why we did it is because what at one time was a maneuver of inside baseball in some respect, immediate effect, has burbled up to the surface. Now people understand that immediate effect was never intended to be automatically given to every bill. I mean, the whole idea of putting it in the Constitution was to protect the rights of the minority, whoever that minority party was, whether it's the Democrats or the Republicans.
And 546 of the bills of the 566 bills passed, 546 of 566 have been passed under immediate effect. So you're absolutely right. It's commonplace.
That's abusive, and that's why I say why are the Democrats?
It's absolutely abusive.
Why are you not? On bills that they require 75%? Why not just as a block just say sorry, we're not going to go that way, and just we're going to immediately effect it back and oppose. I mean, especially on some of these issues, what's the incentive at this point of working at a disadvantage, and at a disadvantage when you lose? Being abused, so to speak. I mean, why not just say we're going to? It's only a short period of time. I mean, there's a good chance that the people that you'll be negotiating with next year would be, much more reasonable to discuss these issues with.
Well, I mean, the thing is that, from my vantage point, the majority, if they recognize the Constitution, okay, which they are not, but if they did, the whole idea behind potentially using the withholding of immediate effect as a bargaining chip is just that. There are a number of bills that the majority can't afford to wait, some period of time after the end of the legislative session for it to go into effect. Like take, the governor's tax changes, for example. I mean, there are certain things that the majority very much needs to have immediate effect on, and the minority knows that, and so the whole idea of the Constitution requiring a record roll call and requiring the supermajority is to force the majority of whichever party in power to negotiate with the minority to say, look, this must go into effect immediately. What do you need to be with us on immediate effect?
Right.
And then you start the negotiation process. That's the whole idea, to protect the minority. What the majority has done is basically failed literally. I mean, our entire caucus can be on the floor waving our arms, asking to be recognized, and they will simply not recognize us and say immediate effect is ordered on a voice vote.
But I'm talking about any of these other bills that the Michigan Medical Marijuana Act specifically.
Oh, right. Well, what we're doing now is every time they do that, we are, as a block, we are entering our no vote explanations in the journal because the only thing we can do at this point is to make our record for future lawsuits.
Right.
And just to keep. I mean, is it futile? Well, maybe. But can every judge in the state, consistently, basically turn a blind eye, toward clear constitutional language?
Right. Well,
I don't know.
Right. Well, when these bills come to the House floor, there's 4 of them. Do you see the House Republicans getting a 75% vote on them, or do you see the Democrats at least getting 26% and having them not get through the House, advancing past the House?
I don't see at this point the Republicans having the required number that they need from within their caucus. I don't see that. Well, actually, they don't, because you need 2/3.
Correct.
You need 2/3
no,
vote in the House.
75%, three quarters.
75%.
You need okay, you need 3/4. So out of 110, they would need 25, 75, another 78, 81 votes.
78?
81.
Yeah, they don't have it. At this point, they don't.
Good.
Well, thank you for that good news.
But the question is, are the, do all the, I mean,
but they're going to try to get it. I mean, I mean, look.
They make compromise.
I mean, hey, listen, our good friend, Representative Kavanaugh, who's been on the show 3 times, has been very open about it. He supports, he was endorsing the bills from the committee. I mean, we know that he's there and, trying to, as he said, make them least, punishing to the community when they go through, because he knows that, where it's a law enforcement and not a public health issue. It's been driven as a public safety issue, and he's there to try to lighten the pain of the bills. But
4834 can't be lightened.
Yeah.
It's one that we really need. We really need a solid block of people to stand up and say no to.
And that bill represents about 7 or 8 different changes to the law. It is not just a single thing. And if people are not careful when they read this, they will not catch some of the subtleties and nuances that Chad has mentioned earlier today could be used against patients without the knowledge of the representatives that are passing the bill.
And since we know that the source of it is from the law enforcement lobby, then we have to assume that they know what they want to use.
I want you to understand this analogy we've used. I mean, a friend of mine, another lawyer, used this in a case, and I use it in some of the other discussions. But like when a person, when you have an initiative or a referendum like that, we use the example of like the chickens want to change the law because they don't like the way the foxes are treating them. So they go out and they change and say, now that this new law says that the foxes have to treat you differently, and they give it back to the foxes to implement it and use the law, as the chickens want it. And the foxes say, we didn't want the law changed in the first place. We thought we were treating you pretty good, and we thought that nobody voted for it. So we'll show you how we're going to implement it, and they ignore it, And that's kind of where we are now. The thing that changes is if you can have a presentation of the cases when the foxes aren't, doing what they're supposed to do in front of a pool of other chickens, right? Then the chickens are able to evaluate the law and make these decisions by way of jury trials, what I'm saying. And, that's what will bring about the social change. But that element, somehow in all of this, the people's law, as you described it as well, is not being heard by the people. And it's that same institution that's preventing it from getting there. And the question then becomes, how do you change that, long-standing...
Having a strong jury trial language in 4851 would be a redeeming feature to some degree, and we.
I mean,
go ahead.
Yeah, I mean, the thing is that you've hit the nail on the head, and this needs to be a much larger coalition. I mean, this needs to be about access to justice. It needs to be about fundamental democratic principles that we all, thought that everyone was buying into.